just a quick intro as requested. Alex is joining us today, and he's got some slides for us to share. He's got some slides for us to see that he's going to share, obviously leading on landlord and tenant kind things, but very happy to answer questions later on any subject that fits in his own bit. Alex is principal of Helix Law, who are at Brighton and Eastbourne, and he's very well known in the landlord community, and he's done some fine stuff for me and for other members as well, I think, and continues to do so. So welcome, Alex. Thank you for coming.
Thank you. No problem, Sue. Well, look, thank you for that. And yeah, I mean, look, just briefly, if I take from there, if you like. So I'm a litigation solicitor. I specialise in disputes and problems. Part of that relate to commercial, property-related disputes, if you like, kind of more complex, higher-level disputes. And then at the same time, we also have sort of investor-related problems, I suppose, which sort of landlord and tenant fits squarely into that. And in particular, you know, evictions, property problems, if you like, is really sort of how I would encourage anyone to think of it. So perhaps if I just try and share screen, let's see what happens here, okay? I make no promises, but let's give this a go. Let me know kind of what you can see. Yes. How does that look promising? Yeah, okay, good. So, I mean, look, Rupert, Sue, just sort of asked me to give an update as to where we are right now in terms of landlord and tenant from an eviction problem perspective, especially. Sort of whistle-stop tour, generally, direction of travel. There's an interesting case at the moment that I'm going to just touch on as well for corporate commercial landlords amongst us, and then really opening the floor to any questions that anyone may have that you might want to pitch at me. So just sort of very briefly, if you like, kicking off, really these are the items that I just had in mind to be looking at today. So sort of the current position, I've said, this case, very interesting if you are in particular a company landlord. Where I see is sort of moving short term, longer term. I think it would be naive to think there isn't going to be a long-term impact of everything going on, sort of things we're hearing, seeing, etc. in relation to this from a landlord perspective, if you like. And then, as I've said, Q&A. So just moving on from there, current position. Well, as you all may know, bailiff enforcement on evictions is currently paused, okay, so until the end of March. I would treat that date with a high degree of skepticism, okay? I think it highly likely that is going to be extended. We know that lockdown, I should emphasize actually, I know some people are joining us from abroad. Everything I'm talking about is specific to England and Wales in particular. I say that almost as though it's a given, but that's my area of expertise and practice. So here, just in terms of the extension, well, at the moment, we know we're in lockdown until at the earliest 12th of April. I thoroughly expect that at the very least, bailiff enforcement is going to be extended until at least that date. And in practice, it may actually end up going beyond that date. So I think very much a watch this space on that side of things. Again, as with all of these things, we've been through sort of highs and lows, if you like, in relation to earlier suspended eviction processes, completely suspended. That's not quite the position we're in right now. The sort of the pause, if you like, at the moment is directly linked to bailiff enforcement. And I'll come on to that in a moment. But the key point here is that from the perspective of a landlord and serving notices, you can still serve notices, okay? And if there are problems or if you need to do so for any reason, then I would encourage anyone to get on with it, okay? There might be this sort of misconception that you can't do that until end of March as things stand, and that's not right. Okay, you can serve notice, you can even issue claims, and people are doing that every day of the week. But there's some really interesting stuff sort of floating around, and I think at the end of last year, towards September, October, when the sort of the complete pause on evictions was coming to an end, so that had been completely closed out. You weren't even able to issue a claim for possession in the first lockdown, if we call it that. March to September, October time. Obviously, the number of claims, etc., sort of fell off a cliff. And then we arrive at October, and landlords are then able to issue possession claims. And there was this sort of an absolute torrent of PR that was kind of thrown at landlords and tenants, and just kind of, you know, generate an awful lot of noise around, oh, there's going to be this tsunami of evictions, you know, claims are just going to go off off the chart. And here we are, the Ministry of Justice deal with the sort of compiling of statistics on all of these claims. And we can actually see now the data for the Q4 2020. And we can see, you can see the numbers at the bottom of the screen there. It's it's gone completely the other way, in the sense that Q4 2020 claims, and in particular by county court bailiff attendance, they're down by approximately 96%. I mean, it's an astonishing number. Sorry, 93%. These are incredibly high numbers. And I think, all we can take from this, it's obviously changing, it shifts, it moves around. But all we can take from this really is that the number of claims are at historically low levels. And I mean, the data itself, the full report from the IJ goes into this in a bit more detail, but in as simply as I can put it, they've never been lower. Now, I sort of, do we see from that means landlords are sitting on claims and not pursuing them? Do we take from that tenants are paying rent and that perhaps the perception of the fear is greater than the reality? You may all know more about that yourselves in terms of your own experience of this, but the numbers don't lie. The number of claims are, as I say, historically low, and we wait and see what Q1, Q2 of this year look like in the months to come. But I don't know if your sort of perception of the fear, if you like, of possession claims matches that reality, and that is hopefully certainly a talking point, a point of interest, I think, when it comes to this kind of concern that landlords legitimately have on the amount of time evictions can take. I should just touch on that briefly. I mentioned it above. Notices at the moment, 6 months long. That's a long period of time. They were historically 2 weeks or 2 months. We've now all got used to the fact that they are 6 months. But realistically, if you are a landlord or an investor and you have a problem tenant who won't go, say after you've served a notice, you're into a 12-month plus type process now. And that is the new reality. But the reason I mentioned the good news or above or below, effectively, we can't actually see those sort of claims, if you like, that people have been concerned by in process. It's just not happened yet. Whether or not that is a bubble, I pose the question. Nobody yet knows the answer. But that's the current data, if you like. Just moving forwards from there. The business and property courts remain open and they're very busy. And this might be something that people aren't aware of, but those courts have actually never closed. So anything to do with money, anything to do with, say, commercial disputes, you're absolutely able to pursue those issues. They actually have never closed in terms of the coronavirus. They've remained open right the way through March to date, throughout 2020, and as I say, to date. So there's perhaps a slight misconception. We're really here very limited in talking about evictions being paused or delayed, not other commercial disputes. And the rationale behind that is that where, say, tenants are evicted, there can be knock-on implications for, say, local authorities to have to rehouse those tenants in terms of public time and obviously social distancing and what have you. There's obviously a lot of pressure to delay and to prevent that sort of very public sort of process, if you like. And that's where the evictions pausing and delays issues kick in, but that does not relate to other commercial disputes. So again, if we're talking about this from the perspective of problems, obviously typically with tenants, we're talking about money being owed. There are still routes available to landlords, to investors, where, say, rent is owed, where money is owed, including where, say, there are guarantors. You might traditionally have sought to reclaim possession of a property at the same time as, or even before, reclaiming those monies. Well, now, question mark, does that position change? Do you look at reclaiming the money before you, or at the same time as tackling possession? Each case different, but it's certainly something to be thinking about, I think, given that the courts remain open for money claims. Again, I talk about more general kind of disputes here, higher level in many ways, disputes, commercial cases. So anything in relation to special purchase vehicle or SPV, partnership, shareholder, joint venture disputes, claims regarding money, guarantors, as I've said, failed developments. We see a lot of off-plan, on-plan investment disputes. These are all carrying on, they're continuing, okay? And to a lot of extent, there's a lot of pressure because the courts are busy dealing with these disputes. At pressure, there's a lot of sort of, as I've said, pressure on the court process. So, those are continuing. In the back of my mind, and again, you will all know a lot more of this than I will, but I sense there's a degree of slight concern as to, say, asset values, other creditors perhaps being more aggressive in pursuing things, whether or not positions might worsen. And so there's a little bit of impetus around protecting one's position, perhaps slightly more aggressively than there might have been at this time last year, simply because of how long this thing is sort of continuing. So that's the current position in terms of evictions and sort of more commercially, if you like. Moving on slightly, so a recent case, Northwood and Fern. This is a case that particularly has a sort of an impact or implications for commercial landlords, by which I mean limited companies. Okay, there's obviously been a move for lots of reasons, including tax mitigation reasons, by landlords who might have historically owned property personally into, say, limited companies. And so there has been an increase in the number of company landlords, if you like. And all of that sort of that process, I guess, a company that you or I might own as an individual is covered by the same law as much larger companies. Now, obviously, there are additional and different accounting rules, and there can be additional legal complexities for those businesses. But in terms of core kind of corporate law, well, the Companies Act 2006 is a huge piece of legislation that applies equally to a company that owns, say, one or two properties, in much the same way as it might apply to a PLC. So there's no sort of separation in terms of baseline legal principles. And this applies here in relation to section 44 of the Companies Act. And I try and avoid talking in too much detail in sort of seminars like this about legal position, but this is directly relevant here. And what that section says is that a company is a legal person. Okay, so just like you and I, a company can be sued, it can sue, it is a legal person. But the question then becomes, how does a company validly authorize anything? Okay, and this section covers that, and it allows, in effect, a company to execute or sign validly a document either by affixing its common seal, some sort of Dickensian process nobody ever really engages in, to be completely honest with you, or by signature, but only if it's signed by two authorized signatories, meaning effectively directors or director company secretary, or in the alternative, by a director in the presence of a witness. So in other words, by a deed. Now that's important because in the case of Northwood, well, for reasons I'll go into, but the key point here is it's not sufficient technically under the Companies Act for a company to be seen to be executing a document without that signature being witnessed, unless it's by two directors. And so you might find that, say, in lending applications or other circumstances with formal documents, you're asked to provide either a witnessed document, being the classic way, or perhaps two director signatures are required. That is precisely for this reason, in terms of compliance with section 44. And of course, the kicker here is that this equally applies to notices and eviction claims by these companies in any circumstance. Okay, and this is where Northwood start to come under pressure and come unstuck. And if I just talk about this briefly, the claim was effectively a Section 8 notice. The agent had signed the Section 8 notice on behalf of the landlord, not unusual, and the tenant had basically made a counterclaim, again, not unusual, something for landlords to be alert to and aware of. But that counterclaim specifically relied on the fact that the prescribed information had not been validly signed by the company in compliance with the regulation. Now, if we just fast forward, I kind of that gives you the whistle-stop tour of the detail. As I've said here, so there is a counterclaim. So effectively, they suggested the tenant claimed that it had been signed by a single director, not two. You will recall the section 44 requirement for two directors or a deed. And so in effect, the tenant was alleging breach of section 44. Good news for landlords on the one hand in terms of the outcome, and I think this was a January High Court case. So effectively, it's just come out on appeal, effectively to the High Court. On the one hand, the notice need not be signed in accordance with section 44. So good stuff there. An agent can sign a section 8, doesn't require two directors, does not need to be a deed, notice was valid, etc. for that reason. And I don't know if any of you are aware of the content of the section 8, but it does allow for the signing by a landlord or an agent. And that was the saving provision effectively, which protected, in this claim, Northwood, simply because they were able to suggest, slightly weirdly, that the director, the single director, had signed it as an agent of the company rather than that signature amounting to the company signing it itself. Just subtle distinction there. But anyway, the Section 8 notice was valid, succeeded on appeal, but the problem related to the prescribed information, and the court held that it had not been validly given. And the reason for this is that there's a subtle distinction that, being completely honest with you, may have escaped those drafting this legislation when it was brought out. You know, you do see these slight anomalies where the Section 8 Housing Act 88 content allows for the signing by an agent. The Prescribed Information Order 2007 in relation to prescribed information does not. It requires that a certificate, i.e. the prescribed information certificate, is signed by the landlord, meaning an agent cannot do that on behalf of the landlord, meaning that the landlord here could not rely on the saving provisions of agency law. And of course, we find here that because it was not signed validly, effectively the landlord's at risk in relation to the counterclaim by the tenant. And that goes on to have implications in terms of the validity of the notice for that reason, not because of who signed it, but because of the prescribed information, etc. So the conclusions here are, number one, notices can continue to be signed on an agency basis, relying on the catch-all of agency law, including by agents, including by a sole director acting as agent for the company. But the second conclusion is that prescribed information must be validly given by the landlord. And where we're talking about a company, that means either evidenced by deed, sealed by the company seal, or signed by two directors. As crazy as all of that may sound, that is the reality. And so obviously that has implications for how people are going to deal with this and process it, including themselves, including with agents. I think there can be this sort of perception, if you like, that, oh, well, I've instructed an agent, I don't need to worry about this, they're on top of it. I would say to any landlord in any circumstance, no, the buck stops with you, okay? And this is exactly the sort of thing that I would be hot on, to be honest, just to protect yourself and your ability to serve valid notices and your ability to prevent claims later down the line, your ability to evict bad or problem tenants, if you like, if you need to do so. Fortunately, this is the sort of issue that can later be remedied. Okay, so that's good news, if you like, in the sense that, say, you have to review the papers and you see that the prescribed information has not been validly given, you can rectify it. But if you hit that point too late, i.e. if you've served your notice and you've waited 6 months, you have to restart that process. And if you only become aware of this, say, where you've served your notice, issued your claim, and then tenant has defended, again, you would have to discontinue that claim, go right the way back to the beginning, deal with the prescribed information properly, serve a new 6-month notice, and kick the whole thing off again. So you can see how you would lose a lot of time, you'd lose a lot of money, and obviously that's to be avoided if possible. If you don't do that, then obviously any company landlord risks having issues surrounding the validity of the notice and being liable for a sum. It can be up to 3 times depending on the circumstances in accordance with Housing Act 2004. So that kind of, again, whistle stop just in terms of the impact of Northwood. Really happy to field any questions on that, particularly at the end, if anyone has any. In terms of where we're heading, well, firstly, I don't have a crystal ball, okay? I can only talk to you in general terms about what I see at the moment, what the talk is of, and what I think is a natural sort of consequence of the current position and what we've seen happen in the last year. The first is that I think personally there may well be an extension of the current prevention from eviction sort of process, if you like, from beyond the end of March. It doesn't make sense to me that they're not married up in terms of the end of lockdown. We've seen this extended at almost no notice previously. Again, I don't think that will impact claims. I don't think that will impact notices or anything like that, but it will impact literally bailiffs making appointments to attend and to evict tenants. And so that's what I see in this very short term. Long term, we already know that pretty much everybody is now committed to abolishing Section 21s at some point within this Parliament, I think has been promised. And that means in the next few years at most. It's a real kind of vote winner that I see at the moment from a PR perspective. And so I think that will happen. That's difficult for landlords because no fault claims, no fault evictions allow you access to an accelerated possession route, albeit still 6 months and for the accelerated route. But no hearing, cheaper costs, etc. That may all fall by the wayside when Section 21s go. Again, I've seen people talk about, well, they'll put in a new process with a Section 8 notice, and that may well be the case, but I think it would be naive to think it will be equal to or as straightforward as, say, a Section 21 claim validly pursued, because the whole rationale behind this is to effectively appease the tenant lobby and the PR surrounding all of that, as far as I can see it. So I think, again, there are likely to be further changes to Section 8 that come in when Section 21s are sort of abolished. For example, you can see how there might be some exceptions in your ability as a landlord to evict someone if you intend to sell a property. But again, from my personal perspective, I think we're moving into an era where it is harder, it is more expensive, and it takes longer for a landlord to evict a tenant. And that simply is the reality that I see. I think it would be very hard to go back in time now in comparison to, say, the pre-coronavirus sort of restriction period of time, if we call it that. Separately, I can see that any of the procedural issues surrounding compliance, you're going to start to see cases come through on this. So where, say, landlords may not have served a reactivation notice in January with an existing claim and it's been booted out, that may well go to appeal. You may see some things coming through there. So that won't surprise me at all. Perhaps question marks surrounding this most recent case and people, say, appealing, etc., pursuing those to try and challenge the validity of notices to buy time to rewind back the eviction process in those claims. Again, I can absolutely see that. I think it's almost inevitable that we're going to see an increase in claims, okay, because as I've said at the outset here, they have an incredibly low base at this moment in time. The drop-off has been absolutely astonishing. And, again, I don't know quite how that marries up with, say, money claims. It would not surprise me to see that money claims have increased in that period of time, but transparently, I haven't looked. But again, I think possession claims are going to increase. It seems to me a lot of landlords have also been incredibly patient, and notwithstanding the lack of support, they've perhaps been able to sit on circumstances, not wanting to put tenants under difficult circumstances while that's going on. Completely separately, two big things I think are going to come in terms of process. The first is that we can already see a huge push towards mediation. Okay, mediation is a form of alternative dispute resolution, and what I mean by that is this has been sort of long established in commercial disputes where there's a public policy argument to try and keep claims and disputes out of the court process, and really we see this via mediation where parties completely off the record, confidentially, are encouraged to meet with one another to try and secure agreement and avoid the need to ever put these claims before a judge. And that, again, whistle stop is what mediation is and is about. It's a fantastic process in commercial disputes, as long as the parties sort of use it cleverly, if you like, and position themselves well in a mediation. The difficulty I have with landlord and tenant matters is that, my concern is this could end up being a slight box ticking exercise. Now, I hope I'm not too cynical there, but the key problem is that it was ever thus that tenants can make promises either to leave or to make payments or X, Y, and Z. And the landlord's difficulty is none of those are currently enforceable unless you go on and obtain court orders. And so, again, my experience is most landlords do not sort of hit a problem and immediately go off to court. That's not the aim. They try and have the conversation anyway. That we are trying to resolve these problems without needing to go in front of a judge, if you like. And so I'm not sure here that mediation will add huge value, but it's coming. And I think, again, the rationale for that is to slow up the volume of claims that people are concerned are coming. And then finally, really potentially a housing court. And the rationale for that is to take out, if you like, the volume or the type of claims out of the general court process into a specialised court. We've seen this in items like leasehold disputes previously that are now dealt with by what's known as the first tier tribunal, property chamber. Scotland obviously have their own housing court. What I would say is, pre-coronavirus, their experience was that it had significantly extended the amount of time that it took landlords to regain possession. Now we can already see from the same statistics that I mentioned earlier in terms of the October to December Ministry of Justice numbers, that you're already looking at about a year to evict a tenant. So you know, I dare I say it, but can it get much worse from a landlord's perspective if you do need to issue a claim? But a housing court, there's a lot of talk that may come further down the line. It might require money. There may not be money to do it. So who knows? But that's certainly kind of moot point at the moment. I think specialist judges wouldn't do any harm at all. But whether or not that's good or bad for landlords, who knows? But specialist judges would be great. As an aside, at the moment, you can turn up in the county court and you can be in front of a family court practitioner, which most people don't realise. You know, it could be a family court solicitor rather than a housing judge. So, you know, that again is the sort of thing that you're dealing with as a landlord in issuing a possession claim. You really do have to put it on a plate for them just to make sure you get the right sort of outcome. So that's me. I've thrown a lot at you all, but sort of very much whistle stop Friday afternoon, and there we are. So I kind of wanted to open the floor just in terms of any questions, anything that sort of anyone has that you would like to discuss, that you'd like to raise, landlord and tenant related, of course, anything sort of more general, if you like, commercial litigation, property litigation. I'm very happy to field that, or even just generally. Any questions?
Right, well, we seem to have some in the chat box, but I don't know whether anybody wants to pitch in, and then I'll go through the chat box later.
Why don't I? Let me have a quick look. So I'll just have a skim read. So I can see, Mandeep, thank you. So you ask, can the signature be witnessed electronically by someone remotely? My solicitor has conducted a couple of independent legal advice documents for PGs remotely. What a question. I mean, it's a great question. First things first. And I mean, the Law Society have issued a practice note on this, and I'd encourage anybody to try and get a hold of it. And on the one hand, and then on the other hand, to try and understand it, because I can assure you it's not a page long, and this is not a bullet point type process. It's an incredibly complex question. In terms of the answer, my view at the moment is that electronic signatures are valid on contracts, okay? And so in terms of, and this is pretty much in line with the practice note I've just mentioned, electronic signatures, you know, there's no issue with that in the sense that as a bare contract, that is my signature, I can confirm that, and you have to prove that, you have to evidence that in the same way as you have to evidence it if it was, say, a wet signature on a document. But there's nothing to suggest that that is not valid. A deed, however, is slightly different, meaning can somebody's signature be witnessed? And you know, this is very much a live issue in terms of risk. And so my advice right now, I mean, if say a lender is prepared to accept a sort of say a Zoom witnessed signature, or say a deposit protection scheme are prepared to accept that, whether or not it's legally valid is really academic. They're happy to accept that as being valid. And you know, I've assisted landlords, investors with witnessing documents in that way myself. But at the same time, I think it would be wrong for me to say there is no risk involved in that, particularly in relation to these arguments. And we kind of, again, for quite a long time, the context here is really important, I think, for us to understand. For quite a long time, tenants have almost automatically qualified for legal aid. And so a landlord who is perhaps self-funding a claim can turn up at a possession hearing. And this has happened to me as a solicitor. And the first thing you're presented with is a barrister handing over a skeleton argument, tearing to shreds by whatever means they possibly can, the validity of the notice, the tenancy agreement, all sorts of problems are kind of thrown at you. And the pitching for an immediate adjournment and or strikeout of your claim. And you know, this is partly how the Northwood claim comes about. So you can face an awful lot of, frankly, mudslinging, some of which may be valid, some of which may not be valid. But that's very much the context of all of this. So I would say to any landlord, you know, if you are in a position where you are needing to contemplate a claim, make sure your claim is as vanilla as you possibly can. You do not want to be the person in, like in Northwood's situation, where there are cross appeals from one another. You don't want to be engaging somebody like me to undertake that process. And so if you don't have an alternative, you don't have an alternative. But in terms of my sitting here saying, yeah, that's fine, don't worry about it, you can have it electronically witnessed, I'm not so sure about that. I would try and avoid that if you possibly can. And most of the time it is possible. So I would avoid it. That's quite a long-winded answer to that question, but it is quite complicated, and it's going to be a live issue whilst it takes kind of legal process and legislation time to catch up with advances in technology, basically, in terms of witnessing. You know, just as an aside, Land Registry are accepting virtually signed documents at the moment, precisely because of coronavirus. So that might, again, winds of change perhaps assist. I hope that answers that question, Mandy. Cash, I'm just going to jump into your question. So prescribed information to be valid, a notice on company letterhead with a seal should be enough. Well, if it's validly sealed with the company seal, and then it's in accordance with section 44. So yes, that's fine. That is one of your options. It's not the one most companies, most landlords would ever take, because they would simply sign the document and probably assume as a single director that that's valid. As I've said throughout, that's not. You either need to have that signature witnessed, so it's a deed and then it is valid, or have two signatories. But yeah, I mean, look, if you're saying it's with a seal, absolutely, that's the other third alternative under section 44. Radislaw, is it recorded? Yes, it is. Get in touch with Rupert or Sue about that one. And similarly for you, Shane. Oh, Shane, thank you for answering. Let's have a quick look. So Mike, what's my experience with commercial property? Is the data similar to the residential data we presented? Why would you anticipate commercial occupiers to start leaving? When would you leaving it? Right. So Mike asks, when would we anticipate commercial occupiers to start leaving in larger numbers? You may not be aware of this. Commercial is completely different, okay, and is not covered in the data that I mentioned earlier in those reports. As far as I'm aware, I don't think that data is recorded. And what you're really talking about there, commercial property, completely different legislation, completely different landlord and tenant laws, if you like, that can protect tenants and landlords. At the moment, there is a stay on the ability of commercial landlords to forfeit leases, okay, meaning that commercial tenants, businesses, are in arrears of rent, or maybe in arrears of rent, but a commercial landlord cannot evict them, cannot sort of pursue forfeiture. The route that most commercial landlords are taking at the moment is to issue money claims, in my experience. And so those claims are continuing, and there's a couple of reasons for that. Number one, it will protect their position in relation to liability of the judgment, i.e. the amount. It will crystallize the debt, if you like. But number two, it normally, and it's difficult this because the content of leases varies very significantly on the commercial side of things. There's no kind of standard AST, as I'm sure most people here appreciate. Leases can be very different, but notwithstanding that, in commercial leases, you can find some standard clauses, including events in default being a kind of a standard, if you like, set of terms I would expect to see. Judgments, any form of insolvency, can amount to events in default. And so, although landlords are right now prevented from taking steps to forfeit, by obtaining judgments, they are able to position themselves to be able to take those steps as and when they can, i.e. when this is eventually released. And the secondary point on why they might obtain a judgment now is in relation to guarantors, if they have any. There's no stay, there's no pause on pursuing a guarantor of a commercial tenant now. And so again, sort of all of that goes towards looking at the detail in any given case, but all of that's going to happen. And my experience, I think you're going to see a lot of corporate vehicle movement, meaning say CVAs, in relation to this whenever the end of forfeiture is coming into play. You already see this in relation to administrations, different setups. We all know of companies like Debenhams and Boohoo buying them out, people like that, Topshop in Arcadia. All of that is going on at a high level, but it's actually going on at a low level as well, or lower level. So in terms of, I guess your secondary question, when would you anticipate commercial occupiers to start leaving in larger numbers? Well, the tenants would probably leave. I mean, it's so fact specific, isn't it? Because at the moment they've got a continuing liability, i.e. for rent, service charge, etc., that they probably wish they didn't have. So I'm sure they'd love to go. But you've also got landlords who don't want to let them go because they've got an absolutely depleted market right now. So actually landlords might want to hold the tenants into the lease rather than allow them to go. So you've got so many different moving parts in that. But at some point, I think quarter one, quarter two, they have to release the stay at the moment on forfeiture, and that will be a kicker. I think a big moment. Mike, I hope that kind of answers your question. Chuck anything else in if there is anything. Let's have a quick look at some of the others. Any advice on selecting residential tenants going forwards? I assume good credit plus homeowner guarantor. Carol, bang on point. I think that's right. Yeah, it's all of the standard things that you would expect. but you have to price in now the risk that, furlough, jobs, my goodness, and the length and the cost of the process if you do need to evict. I think homeowner guarantor is, bang on point. It costs you £3 to obtain a land registry office copy entry to check a guarantor owns a property, and the leverage that can create if you can obtain a homeowner guarantor is just off the chart. We can be pursuing the guarantor for all of the arrears, meaning that you can take a much more, relax is the wrong word, but you're in a completely different commercial world than, say, a landlord who is having to not only fund eviction but possibly fund a mortgage, any outgoings on the property for maybe over a year. That's a nightmare for people to be involved in. So yes, absolutely, Carol. I think the other point that hopefully kind of comes across here is that being absolutely on top of your paperwork is key. Good credit, homeowner guarantor from that side of things, but absolutely making sure you're Johnny on the spot with paperwork is huge at this point, because losing 6 months is just, that would be a killer if you're not receiving any money and if you're incurring costs in an eviction. So don't allow yourself to be put in that position. Carol, I hope that helps.
Quick add-on to that.
Yeah.
Anything you could do with the employer? Sorry, I've got one person that's inquiring after a place. They've come from abroad. They've got a permanent contract. It's local. It's a good wage, but they've got nobody they know locally. So I just wondered if there's anything there.
I think the reality is all you could be thinking in those terms would be, say, an agreement of some description with the company, with an agreement that they can sublet. I mean, that can create its own problems, obviously, but that would be one way of mitigating the cash flow risk. It can create different risks. You could have a corporate guarantor, I should say, as well. I mean, there's nothing to stop, say, a company acting as a guarantor for a tenant. But again, what are ultimately the assets of that employer?
That company to be able to pay the debt.
Yeah. And so, I guess it rapidly gets to a point where you would almost be asking, say, a director of that company employer to act as a guarantor. And then you're thinking, really? What's the prospect of that? But, these are very much the kind of commercial risk, cost, benefit sort of processes. You can also look at rent guarantee insurance. Anyone that knows me will realize I'm not a huge fan. I'm not going to lie, just because it just creates problems. And often they'll only insure people who effectively so low risk that it's not worth it anyway, or they won't pay out when you need them for X, Y, and Z reasons. Small print type arguments.
That's one of the reasons why I rarely consider insurance, because
a lot of landlords say that to me.
The one instance I've had it, I was told by the agent, "Oh, you've got 6 months cover," and I actually no, I had 4 months, because they rated it on the first month was paid up front, the last month was taken by the deposit. So they covered the ones in between, and my tenant failed on the last month.
Yeah.
So.
Well, Carol, RGI, I mean, I know a lot of landlords who have paid for rent guarantee insurance and they found that they're not covered for coronavirus. And you think, my God, this is the exact type of circumstance that I was hoping to be covered for. And for various reasons, they've escaped liability. So I don't know. But I think you're bang on point in terms of, good credit, but the homeowner guarantor is just dynamite. Again, just one point on that. You've got to make sure your guarantee agreement is bang on point. It has to be solid. That's a contract in its own right. And I see these guarantees and I can think, oh my goodness, you've got 90% of the way. And then the final 10%, either content of the guarantee, it's not sufficiently watertight. It doesn't allow for, say, recovery of costs. And you just think, oh my goodness, to make sure the contract is good.
The NRLA actually now do a pro forma for it.
Do you know, they do, but Carol, I was actually just about to say, I've got a horrible feeling the NRLA one might be one of the ones that does not include what's known as a cost indemnity. I can't recall if they've changed it when they've amalgamated, but I would absolutely check that, because it's the cost indemnity that gives it teeth. In other words, if you're paying me and I can say to the guarantor, really don't want to have to do this, but obviously I cost £300 plus about an hour. Can you have a word with the tenant? It might be your son or daughter or relative or whatever it is, and maybe we can cut a deal. You can bet your bottom dollar they're going to be on side, because they don't want to be paying those costs, just like you don't want to be. So I'd absolutely check the content.
I would hope that they'd actually done that, because they didn't used to do one. So I'll check.
Yeah. Okay. No worries, Karen. Good seeing you. I could just hear a little bit of background noise there.
To ty ode mnie, tak?
Is that Michael? There we go. Thank you. Sorry, Radislav, what have we got? So you've got a question just around deliberate avoidance of rent.
Yes.
Go on, hit me.
It would be better if I can explain.
Mm.
Other letting agent that I'm friend with passed me the tenant on benefits. I don't usually deal with tenants on benefits, I'll be honest. And that tenant had the reference from existing agent, claiming that agent said that he was paying 2 years with no problem whatsoever. All it takes is just to transfer the benefits over. Tenant moved in, just paid the holding deposit, which was the first week rent. And because I trusted, I didn't follow typical references like I usually do. I just trusted my colleague. And unfortunately, I've been stung by this. So I got at the minute tenant who doesn't pay, doesn't seems to, he was sanctioned, so he lost his benefits and basically can't be asked. I was offering all sorts of help, cash to move out. I was offering help to reinstate the benefits. I was offering help to find a job. Other sorts of reasoning. He just don't care. Literally, I never came across somebody so adamant. So I'm a bit baffled by this. It's first time I'm facing something like this.
Okay, so first things first, I think it's good to acknowledge where you are. Secondly, I see this quite a lot, to be totally honest, okay? And you can go through all sorts of processes, making all sorts of offers, and if people are head in the sand, then you need to rapidly get to a point where you're sort of, what can you control? And what you can control is getting to a point where you can serve a valid notice, and if and when you need to, issue a valid claim and obtain a possession order and evict them, to be completely honest, because that's your default baseline. And at any given point along that process, you can still be talking to them on a without prejudice, off the record basis, trying to cut a deal, trying to agree a surrender. But at least you know that you are working to an end point whereby at some point they are going to be gone, because it's either by them agreeing or it's by you instructing bailiffs to forcibly evict them. And I know that's direct, but that's absolutely the process that you need to be taking here. And I think the sooner you or any landlord kind of start that process, you can actually find that by kicking the whole thing off, by serving valid notice, issuing a claim when you can, the tenant will start to engage more because the writing is on the wall. Whereas the longer you try and say informally do this, they can just sit back, and legally there's very little you can do. So I would encourage you to absolutely get on with it in simple terms. There's a secondary point here. There's a secondary point just here that deals with the misrepresentation, which is what it is that you've just explained to me by the earlier agent. If they've given you a reference that is incorrect and or contains incorrect sort of content, if you like, and you can effectively prove that, or you have any degree of evidence surrounding that, you might have a claim against whoever it is that wrote that. And that would arise under what's known as misrepresentation, which is an unambiguous statement of fact, which is false, that you relied on. And if you satisfy those different sort of legally, we would look at that in each stage, you might well be able to pursue them. The concern here more broadly, and just to explain the context of this kind of, I don't want to use the word battle, but that is kind of how it can feel sometimes between you and the tenant. The context can be that, particularly where, say, you're dealing with a tenant in receipt of benefits, they can be looking for you or any landlord to forcibly evict them. They may actually want you to do this. And the reason they may want you to do this is because right now, as things stand, when you have completed the process and you obtain a court order with a bailiff's warrant, they can then take that to the local authority housing team, who will be, depending on the circumstances, possibly, probably under a statutory obligation, a duty to rehouse that tenant. And when they rehouse that tenant, effectively the rents, etc., for say housing association or local authority accommodation are very significantly lower than private rents. And this can be seen as a way of kind of jumping the queue, if you like, into social housing. And so, again, I know it's frustrating, but the sooner we sort of realize that reality and get on with it in terms of your next steps, you know, that is just an absolute no-brainer. There's a second point as well, there's just one final second point on this, which is that I'm talking to you about possession because I see possession of your property as the most important element, particularly where you're, say, dealing with a benefit receiver. That's immediately suggests to me that they are low income, that they don't have assets. And that means that in terms of recovery of money, your prospects are always going to be, relatively speaking, low. However, you are entitled to pursue a money claim against that tenant for any arrears that have accrued. And when you obtain judgment, and it's basically a breach of contract, they're in breach of the AST, they've not paid you rent. When you obtain that judgment, you can then enforce that judgment via what's known as an attachment to earnings order. An attachment to earnings order typically applies where, say, someone's receiving a salary or employment benefit per month, and it applies as a deduction to that payment from the employer directly to you. It equally applies where someone's in receipt of benefits. And so you can find yourself in a position where you will obtain your same money judgment. You have that piece of paper with a court stamp on it, the CCJ. You can then enforce it via an attachment to earnings order, and you can have effectively a government check coming direct to you as a deduction from their benefits each month. Now, again, I don't have a crystal ball here, and what you can equally find, that's obviously positive. And I know landlords that receive those checks every month, and it just chips away very slightly at the debt. But I also know tenants who will not declare their earnings at 1 month, or they might be on, say, 0 hours contracts, and so they're in and out of benefits, meaning that the threshold as to which the attachment to earnings sort of order, if you like, kicks in is constantly messed around, and so there's very little consistency. So whichever way you look at it, you're taking a risk. Go on.
Is this when if he reach certain threshold, he can be declared insolvent, or like what's the next step? Doesn't pay.
Well, yeah, I mean, you have options. Okay, so I mean, when you talk about threshold for insolvency, we're talking here about the county court process that leads to a judgment, and it either leads to a CCJ for money and or a possession order. These are county court judgments. Completely separate to that process, you have a different process, which is insolvency. And in the case of an individual, you could serve notice and you could ultimately petition for their bankruptcy if you wished. And if you think there's leverage in that, then fine, you can consider it. But what I would say to you is that, well, number one, that's kind of a 0+ game. The reality is, if they are declared bankrupt, your prospects of recovery are next to nil. So that's not great.
That's
Secondly,
what I'm thinking what is happening now. So I'm just trying to use this.
But Radoslav, there's a couple of points on this that I think you need to keep in mind, which are, number one, it's quite expensive. The government deposit for petitioning for someone's bankruptcy and the official receiver deposit, as it's known, they're about £2,000. So that's just to petition. That's not legal costs. That's just to petition for the bankruptcy. But the second point on this is the minimum amount that you can bankrupt an individual for is £5,000. So unless the arrears are more than £5,000, you can't petition for them to be bankrupt anyway. So most landlords do not pursue that as an option because of the cost, because the cost benefit doesn't really stack up. Whereas obtaining a CCJ and then maybe enforcing via an attachment to earnings, that's something that I can kind of see. It's a modest cost, a couple of £100. It's not huge in comparison to a couple of £1,000. And people's circumstances change. You can obtain a CCJ today. That's going to affect their credit rating for 6 years. I've seen tenants who have left, disappeared, landlord got a CCJ, then did nothing. And a couple of years later, they've sort of raised their heads above the parapet because they're now applying for a mortgage and, oh dear, there's a CCJ they need to satisfy. And so they're happy to pay. So, that can be the kind of long game. But I think you have to separate in your mind money from possession where you can. And prioritize what's most important. Really difficult.
It's maybe the first time when I see somebody just so adamant. That's maybe I'm not like distressed by this, but it's just first time I was unresponsive person, and I'm just baffled by this.
Brad,
I know, and it's so frustrating.
Are they over 2 months in arrears?
Yes, they
what I'd suggest is talk to the council and the housing team, because you're in a position where you can serve notice, as Alex has said. But when they're within 56 days of becoming homeless, there's an obligation that falls on the council. Now, it may be that if you go to the council and talk to them, say he's not paying the rent, you could get your payment direct, which will help out short term. They might offer to clear his arrears and pay you direct. but it will, if they get in touch with him and then he continues not to pay his rent, he then will lose the option of being rehoused somewhere, because he will be seen as being making himself homeless. So I'd get them involved, because that gets rid of the option of rehousing himself somewhere else, because if he's deliberately not paid his rent and they've tried to help him, he'll lose any option to being supported, and their obligation to house him disappears.
Carol, if I can ask you, maybe I don't quite understand the whole.
I can talk about it afterwards if you like.
Okay, that's fine. Like Sam. Okay, we'll just talk later. It's off the.
Can we take this one offline and move on a little bit, broaden the discussion? I had the same question about this Prevention of Homelessness Act, Carol, so it's the same thing, isn't it?
Yeah, it's. I can do a separate session if you like and just run through it.
Yes,
that would be very helpful. Yeah, thank you.
Just what you've raised another question here, Radoslaw, just in relation to the MCOR claim, and it's a good question. If you issue a money, and your question is this: what happens to any arrears after I've issued my claim and have judgment? If, say, the tenant's still in the property, that judgment will only apply up to the date of the judgment, and this is a problem with issuing a money claim before you have regained possession of the property. So, in other words, you issue your claim. Tenant remains in the property, you get your judgment for the arrears, but that only covers up to that date. If the tenant remains after that date, the arrears may continue. You would need to issue another claim. And this is kind of why historically we have always suggested and have advised that landlords prioritize regaining possession first. Your loss then crystallizes, you know exactly the sum. You then issue your money claim for the exact sum of your loss. Bear in mind, you can only at the moment claim for rent arrears. There could be damage to the property. There could be other losses. So these are all things to go into the mix, I think, for you to think about kind of commercially, but I hope that helps.
With MCL, I'm thinking to use this a little bit like a deterrent. I will just print them, let's say, court papers. It might just freak them out. More like psychological factor that actually I'm taking action.
Yeah, I think that's right. I mean, I would say to you, strongly, 6 month notice, okay, depending on the amount of the arrears, but I'm assuming that's right. Get the clock ticking on that. That can be your safety net, if you like. It does depend on the exact amount of the arrears, etc. But we can talk about that afterwards if you'd like, and just surrounding this, or equally with Carol and Sue, have a lot of experience, particularly in terms of, say, local authority stuff. That's not sort of something that we would get involved in for obvious reasons. But look, I hope that helps. Something that hopefully helps a lot of other people as well. Vina, you put your sorry.
In the moment, Alex, it was just something that I think kind of goes round in a circle from what you said earlier. You said that the level of claims was very low, and that you implied that you were surprised by that. Yeah. I think that landlords are walking on eggshells, that they daren't issue notice because they're afraid the tenant will stop paying rent.
Yeah, I mean, I think you're probably right on that. And it was ever thus. We do deal with landlords who come to us in exactly those circumstances. So I think you're right in that sense. But it's very much chicken and egg, isn't it? You have to. It isn't. We have to break some eggs to make an omelette.
At the moment, they may tolerate bad behaviour, disrepair of the property, or rubbish all down the drive or whatever, right? Yeah. They put up with that and the neighbours complaining because they're still being paid rent.
Yeah,
they know.
Totally agree.
I know that if they issue notice, then they're going to have multiplied problems. Totally. And I think that's why the notices are not coming out the end of the sausage machine in order to issue claims, or they've got to the end of the notice, still got rent paid, but they daren't issue a claim because they'll trigger the stopping of the rent. So the claims are actually down because of the fact that there's actually no real censure for the landlord anymore. It's so far out that they hope that things will resolve in the meantime.
Yeah, I mean, I partly agree with you, Sue, in the sense that, firstly, we can't know. Okay, we don't know why these claims are low at the moment. So, it's a little bit speculative, isn't it? But at the same time, my experience is that the majority of landlords pursue claims based on arrears of rent. and
I agree.
whether they're fault-based or they're non-fault-based, there are rent arrears that underlie the vast majority of possession claims. And so the question in my mind is, are we suggesting here that the fall in claims means that there are fewer tenants in arrears? Because I don't believe that.
No,
That's
no.
not my view.
I think
And so if that's not the case,
there is misinformation. We see a lot on the forums on Facebook. There is misinformation that you can't issue notice, or that you can't, when the notice expires, even if it's 6 months, they say, oh yeah, but I'm stuck now because I served my section 21, but I can't evict the tenant. So they're not making the claim because their perception is wrong that what they can't do is about the bailiffs, not about the claim.
The very end of the process. I agree, and I think that's right, Sue. Ultimately, I'm surprised, I guess, that is having such a high impact.
Yes, I agree.
It's crazy. Again, if I just bring them up for me, not for everyone, but I mean, it's really, really stark. The number of possession claims have decreased by 70%. 70%. The number of warrants issued by county court bailiffs, 93% down. That's, and you think, well, okay, but are we not in an environment where arrears have increased, that all of the problems have actually increased, and yet the process doesn't seem to reflect that? And then, in my mind, I'm thinking, well, doesn't that basically mean that we have a bubble here of some description? There's a curve, there's a volume of claims waiting to be issued. And I think that could be right. I take your point completely, though, that actually it could be earlier than that as well. There's a kind of a torrent of landlords that need to serve a notice, and that could, absolutely be spot on.
Now, Vinay's had his hand up since about last Wednesday.
He has. I know. Sorry, Vinay. Yeah, go on.
It was a brilliant talk. I really enjoyed that, and I learned so much from it. My question really was, Alex, about the section 44 of the Companies Act that you mentioned. About. Now, I'm a sole director of the property company, and I leave all the management to the agents. I don't get too involved with the tenants whatsoever. So what are apart from signing my contract with the letting agent for the management service, I don't tend to sign any of the contracts, and I let the tenant, let the agents sign the ASTs, give all the documents they need to give to the help to rent guys and whatever they need to give to the tenants, and I don't get involved in anything else. So what would you say, based on the information that's come out from this case, should I be changing in my practice?
I'm going to ask exactly this question.
I'm not quite sure. Do I now have to kind of do certain things myself now? And if I'm signing certain documents with the agency, have I got to get a witness, or a deed, as it is?
And I think that is a huge, it's a huge topic, okay? And trying to give you as clear an answer as I possibly can. There are ways that you might think of trying to improve your position. So, for example, giving the agent a form of authority that formally recognises them in a limited way as having a role as say an officer of the company in a limited capacity. That could offset some of this. But I think ultimately I would be saying deed, that by far and away, for you to sign off personally certain documents, not every document. For example, the notice does not require that. And so, an agent can sign that document. Equally, I don't have a problem with the AST being signed on behalf of. So really what we're talking about here are items like the prescribed information. And I know that it's really tempting, as I said, just to rely on agents to pick all of this stuff up. But the truth of it is, you can really come unstuck, and a lot of agents do not cover this in sufficient detail. So, from my perspective, I can only say what I see right now, as daft as it may sound. But section 44 is what it is. And these are the arguments that you can face from tenant-funded legal aid barristers, solicitors.
So really, the prescribed information, things like the help to rent guide, the EPC, the gas safety certificate, things that we serve to the tenants before a tenancy starts, they're the sort of things that's the responsibility of the landlord or the company, not necessarily the letting agents in law.
They're all your response. Yeah, I mean, just to be clear, they're all your responsibility. Absolutely. Buck stops with you on all of them. Bit more of a technical question as to whether or not they all need to be signed by the landlord. The prescribed information is the one that I'm aware of in detail, because it expressly says, as I mentioned in the slide, it needs to be signed by the landlord. As to the rest, things like the how to rent guide doesn't need to be signed at all. It just needs to be the current version. So on that side of it, you don't need to touch that. But you do need to make sure it's been dealt with properly. And again, what I mean by that is there are different versions at different times. Has the right version been sent? Has it been sent in accordance with the AST, or has it only been sent by email, etc.? And I kind of it can be really tempting to say, I'm paying an agent for that. And that is what you're paying an agent for. I readily accept that. But and I use an agent, so I really do get it. But at the same time, they can vaporize, and it's not a defense, and that's the truth of it. So you kind of have to make sure it's done.
I'm missing this point here actually about signing the prescribed information. What exactly is that? Because I don't manage my tenants, so I don't get too involved with it. But what exactly is
that's a good question. Okay,
yeah.
So any deposit needs to be registered, and it needs to be registered with a prescribed scheme. I think there are 3 or 4, and any of those schemes can be used. They all have different rules, if you like, different forms of certificate or recognition that the deposit has been registered. Typically, that will look like a form or a certificate with, say, terms and conditions behind it. Whatever it looks like will depend on the scheme used, but that will form the prescribed information. There is a legal requirement that a tenant receives the prescribed information in relation to where their deposit, their money is. And this is effectively the terms and conditions as to when there might be deductions, what should happen to that deposit, where it is registered, what the reference details are, what will happen when they leave the property, etc., etc., etc. Historically, this is to prevent tenants at the end of a tenancy issuing claims, because the volume of claims was snarling up the court process. So it's kind of been carved out into a deposit protection scheme arbitration type process. Prescribed information covers all of that, and the exact form varies depending on the scheme, but that's ultimately what we're talking about. And it's important that that's given to a tenant, because ultimately you can't serve a valid notice unless that has been given. Now, the tenant here received that prescribed information, but it had been signed off by, I want to get it right, it was either the agent, or I think it might have been one director, actually, in this particular case of Northwood. And so the tenant raised the point as to whether or not it was valid. And that's the heart and soul of this. I think it was the agent from memory, but forgive me on that, but it's one or the other. And the point is that does need to be served validly by the landlord, meaning needs to be signed off by you as a director, witnessed for it to comply with the deed, every single prescribed information, any deposit, etc. If I were in your position, I'd be going away and doing that. Just have them on file. And all you're doing, you're printing them off, you're signing them in front of a witness, scanning them so you've got a copy, popping them in the post to the tenant, just for the sake of completeness, here's another copy, bang, done. If you ever need to serve a valid notice, you've ticked the box. And again, Vino, kind of just to reassure you, I suppose, if you don't do that and you fast forward and you need to serve a valid notice, as long as you pick this problem up before you serve your notice, that can still be valid. So you can do this late, okay? But as I've said, where people become unstuck is that they think it's all done because they've signed it validly, they think. They then serve their notice. They then go 6 months down the line. And it's only when they bring it all to me or somebody like me and I say, you've got a problem. Or even worse, they issue the claim and then tenants defend, etc. And they've got to not only stop that claim, but go right the way back to the 6-month notice period, serve a new notice, kick the whole thing off again.
Yeah. Okay, and is it only with regards to this prescribed information that this rule applies in terms of getting a witness signature? Is it all documents in general that you sign as a sole director of a limited company?
Right now, in landlord and well, firstly, Section 44 applies. So Companies Act 2006, anything that the company is signing needs to be validly executed. Okay, so you're in the realms of company law as far as I'm concerned, which mean that it's ditto with things like resolutions and quorums and shareholder meetings and all of the above. All of that bureaucracy applies to your company just as I say, a Boots, a PLC. It's the same law. So you need to make sure that anything complies with Section 44. In relation to the specifics, in relation to landlord and tenant stuff, it's going to sort of apply to anything where the company is executing a document. And it's hard for me to be sort of sat here saying it applies to X, Y, and Z, because at the end of the day, these are arguments that a tenant would have to run to challenge the validity of a notice. That's the context in which it would be run. So it's kind of, how do I prove a negative? So all I can really say as I sit here right now is this is the live issue because this is a document that the landlord has to sign. It can't be signed by an agent of the landlord. And as a result, this landlord has come unstuck. Don't put yourself in that position. Does that sort of help?
In practice, yeah, I think in practice, it probably, I'm thinking about all the situations where I sign on behalf of the company as a sole director of any one of my businesses, and even things like the company accounts that I sign off and send off, and, you know, tax returns and whatever I sign off. I'm signing off on my own without a witness, and you know, it's new to me actually, so it is something to be aware of. And
yeah, I mean, we're touching on here without meaning to, but you know, you rapidly move towards, say, joint ventures that go wrong, shareholder disputes, director disputes, boardroom disputes, in the sense that you have this whole avalanche of law that applies. You know, Articles of Association, Companies Act 2006. I mean, the Companies Act has over 1,000 sections in it. To give you an idea, it is a vast piece of legislation. That's huge. You know, it dwarfs the Housing Act. So I kind of, all of that is, yeah, that's all relevant here, even though you will never need to touch or think of most of it, but it can be relevant, and you know, they're going to throw these arguments at you. So yeah, I kind of hope that answers the question. You know?
Yeah, thank you. I think it's been really helpful. Thank you so much.
Can I jump in again, Alex?
Sure.
I've always believed that the landlord has to ask for possession. Is that still the case?
Yeah, so you're talking about claim documents. Yeah, and so again, Sue, you know, your voice of experience here. This was probably, I would say, maybe 10 years, 5 to 10 years ago. Yes. A lot of agents were issuing claims, and they were doing it to try and help their landlords. To be honest, I think that's the context of it. But they would be running basically the litigation, and that kind of, you know, the brakes were hit on this. Kind of the handbrake was pulled up because, again, a lot of tenants were defending those claims on the basis that they had been improperly issued.
Are you sure that there's been a break? Because I don't think it has.
Fair. Maybe.
Nobody's talked to me about this. For a long time.
Maybe I only see it.
Know it, but nobody has talked. None of my agents have talked to me about this.
Well, there are other arguments that apply. So, no, so actually the law hasn't changed. This is basically the problem for agents in issuing claims is that they're not authorized to conduct litigation. And so they're not technically allowed to do that, regardless of anything else, regardless of signing off on documents and what have you. I mean, they can't do it for that reason actually as well, just as an aside. You know, they can't validly issue a claim on behalf of somebody else because that is conducting litigation, and that's what's known as a reserved activity. So again, that's sort of, if you like, the preserve of solicitors, you know, but yeah, it's restricted basically. And you were finding that, sorry, I was finding, you know, except what you say, it might still be going on, but I haven't seen this for quite a long time now, but that might just be the circles that I sort of circulate in. But I kind of, yeah, you were finding that agents were drafting and were issuing claims, as I've said, trying to help landlords most of the time. But then tenants were defending on the basis that actually this is not validly issued. And that was coming good. Those claims were failing for those reasons. So yeah, I think you know, very much a live issue as to the extent to which agents can and should go. And you know, my perception is sometimes agents can feel responsible when tenants stop paying the rent or there's a problem with the tenant because they've introduced the tenant for the landlord. And so it's kind of this misplaced wanting to help the landlord to an extent, but it's like, yeah, no, you can really quickly come unstuck with that. You're not insured to do it if you don't do it every day. I mean, my goodness, particularly at the moment and for the last year or so, it's an absolute minefield. And it's going to get more, you know, it's going to get worse, I'm sure. But yeah, no, interesting point.
Thank you.
No problem. Let's have a quick look, just see any others. I think that's covered. So if the figures are so low, I wonder how many landlords are bribing their tenants or undertaking illegal evictions. Yeah, a really good question. I agree, Carol. I mean, I think particularly when you say bribing tenants, yeah, reaching a deal, cutting a deal, most landlords are going to try that for really good commercial reasons. And you know, cost benefit, if you can agree a surrender of a tenancy on a without prejudice, meaning off the record basis, get it signed off and get the tenant out, then, you know, I get that. I really get that. I think, again, most landlords, in my experience, understand that Where it can become a problem is where you come across the tenant and it's no amount of money will do. They won't do it because they want the social housing. And so, you know, there can be other factors that prevent them in their own minds, rightly or wrongly, from considering any deal. And so, again, I would always say, absolutely explore on a without prejudice basis with the tenant whether or not you can cut a deal. And if you can, great, get it done, get it signed, get them out, done. But if you can't do that pretty quickly, don't lose time, you know, because it's actually time that is lost. And yeah, time equals money, but it's just so frustrating when you know, tenants not paying rent and you're perhaps 1 month in, 2 months into this problem, trying to have a conversation. They're hard to get hold of. You have a chat, they promise to do X, they don't do X. A couple of weeks later, you've lost another month. You know, we've all been there, and I see it where people are genuinely trying to do something and it doesn't work. The boss has just put his hand up. Rupert.
Hi, Alex. Yeah, just coming back, I see you looking through the questions, so I thought I'd help you on that. I popped one up earlier about, you mentioned the difference between a deed and a contract, which I was aware of, but would find it difficult to explain to a layman from myself. So
yeah,
that's always my judgment of my understanding of it. But it was quite interesting that you said that if you sign the document and get a witness, then the document becomes a deed. And I thought that was really quite interesting, because my question is, what's the difference between a deed and a contract, other than the fact that if you get a witness to sign your contract, it becomes a deed, if that makes sense?
Yeah, sure. Well, I think first things first, that, well, I mean, there are quite a few differences in legal terms, and some are relevant and some are not relevant at all. So a deed in itself is one that is signed, sealed and delivered, which a lot of people will have heard of. So signed, sealed, delivered effectively means one that is signed, dated, in writing, witnessed. Okay, and that's sort of one document. A contract, effectively an offer, acceptance, intention to create legal relations, again, evidenced in writing, but a contract doesn't need to be evidenced in writing. It can be a verbal agreement, and that is a contract in itself. So it doesn't have to be in writing, doesn't have to be signed, doesn't have to be delivered in terms of being witnessed. Yeah, so again, I go into a newsagent's, I buy a can of Coke. That is a contract. I am offering to pay 50p for my can of Coke. Newsagent sells it to me, that's a contract. There's nothing in writing, but it's still legally binding. I can't walk out with my can of Coke without paying my 50p. So that's an immediate distinction. Legally, there are quite a few other important distinctions, I guess. So without drilling down in too much detail, for example, for a transfer in relation to land to be valid under the Law of Property Act 1925, it must be via deed. So that's why a conveyance, when you're signing a contract, they call it a contract, which I appreciate is ridiculous, but you'll have noted you have to have it witnessed. So it's actually a deed. Yeah. And that is kind of this misnomer legal nonsense terminology stuff that's going on here. But that is a deed, and it has to be to comply with the landlord and tenant, the Law of Property Act 1925. But there's some other I think interesting points around this. So for example, within a deed, you don't have to have consideration. So if I present the shopkeeper with a deed that says he's going to gift me a can of Coke or whatever it is, and he signs off on it, I don't have to give him anything if it's witnessed, if it's in a deed. Whereas in a contract, for it to be legally binding, you do have to have something in the bargain. So I would, and the consideration in that example would be money. I'm giving him money, he's giving me something back. That's the consideration. Whereas in a deed, you don't have to have consideration. So there's kind of these, and that's relevant for, say, a guarantor. In a guarantor agreement, I would want that as a deed, because otherwise, what's in it for the guarantor? Nothing. There's no consideration. And so you can find that guarantor agreements that are bare contracts can be challenged for what's known as want of consideration. Again, these are quite technical arguments. People might not pick up on them, they might not, but it's the sort of thing that it's just headline risk, if you like. And so invariably, if you want something locked down, get a deed.
And is there a situation where a deed doesn't necessarily have to be an agreement by two parties? So I'm thinking about maybe when you're doing a deed of beneficial interest or something like that, where you're putting the beneficial interest onto another party, which might be a company or a different legal entity. Is that part of the answer as well? That the other party doesn't have to actually agree to that deed in that regard?
Well, I mean, okay, I think, yeah, that probably goes towards the consideration point, you know, in the sense that if you were to look at the background as to whatever it is you're talking about there, and you know, the trust kind of arrangement, it would be important that for, say, tax reasons, there is no consideration, because that consideration would then need to be taxable, et cetera, whereas by dealing with it as a transfer under a deed, you can probably avoid that on the basis there is no consideration. So it's a nil transfer in that way. You know, again, I sort of, you can find that, say, declarations, so for example, boundary demarcations, you would deal with that via a deed rather than as a bare contract. And again, that's partly because then you're covered under the LPA 1925. And it's also partly because effectively you're not getting into the consideration arguments on a contract. So there's lots of reasons why in certain circumstances it's better. In litigation and legal proceedings, and particularly in high court disputes that I deal with, we will A, require, and B, be required to use affidavits, i.e. witness statements that are supported via, effectively as a deed, so they're witnessed. And that can be because they can be triggered into contempt or committal proceedings if people lie under oath. So, you know, again, you have that context of this as well. But I guess to a lot of people, this is quite noisy in what I'm talking about, but it can make quite a big legal difference. The consideration argument is a you know, really important point for guarantors, especially trying to bring it back to focus.
Thanks for that. That was really interesting. I'll be on to my daughter later. She's halfway through her law foundation year, so I'll see what she thinks.
Oh, is she? Oh, okay.
Or whether she knows yet.
No, honestly, I love all of that. It's good stuff. And we, you know, again, settlements and deeds of release, we routinely deal with those as deeds rather than as contracts for this exact reason, so we don't come unstuck in that kind of a way. You know, it can again have a bearing on where people are releasing their legal rights to X, Y, and Z. To have that covered off in a deed has a different legal meaning and impact than in a contract. So again, it's just kind of technical, but yeah, really useful and kind of opportunity in my world, depending on the commercial dispute we're talking about, but all interesting. But look, I hope that's kind of helped. I sense there's a pregnant pause in the room. But if there's any other questions or anything, you know, by all means reach out to me. Yeah, kind of happy to field them.
Anybody else want to chip in with questions? I mean, we've covered the ones that I had myself, Alex, because they occurred really from things that you said.
Yeah. And
Carol picked up on my Prevention of Homelessness Act, isn't it, Carol?
Yeah, it's their statutory obligation on homelessness.
Yeah.
Yeah, but there was a I'll use the word act. It's probably not quite the technical word, but something happened, and the central government wrote to the local government and said, hey, you're not behaving right. You must rehouse earlier.
Yeah, it's
yeah, I mean, it's
56 days of somebody becoming homeless. It applies that they have a duty of care, but they'll assess the person, and if they believe that they've made themselves homeless, that gives them a great deal of relief because their obligation is then done away with. But the thing to be careful is.
Sorry, go on. No. Sorry, I interrupted you.
The thing to be careful of is if they discharge their duty to yourself as a landlord, their obligation on the homelessness then is done away with, which always seems a little bit of a, if you've got a really bad person and you give it to a private landlord, I always have a bit of a question mark at the back, so a bit of wariness, I think, and ask some questions. Anyway, Alex.
No, I totally agree. I mean, the legal test that they're applying is whether or not the person is voluntary or involuntary homeless. And that is the kicker, if you like, for the local authority on their obligation to rehouse. So, yeah, I mean, look, long story short, that's what people are. The local authority don't want that obligation, and they will try and engineer circumstances where they're not obliged to rehouse. But equally, in certain circumstances, the tenant will obviously want them to have that obligation so that they can try and bump themselves up the queue. That is not quite as straightforward as whether or not there are rent arrears or not, as you basically alluded to, Carol. So yeah, I agree.
So it's broader than just paying the rent, it's behaving differently as well, is it?
Well, I mean, this again is a good question. I don't act for local authorities in applying this test, and that I have seen them apply it differently. So I think there are different factors they take into account, but I'm not really the person for this because it doesn't cross over into eviction. That would be more for, say, benefits assessment, and yeah, it's not really one for me. I can talk about it in terms of my experience, but that's more general rather than because it's directly linked to my
bet
work.
our friend COVID comes in here as well, in that
All that stuff I think has been suspended. Yeah,
it's going to be a get out clause for everybody, for tenants, for local authorities, and possibly for in other walks of life as well. But the tenant is going to say, well, honest, I did expect to pay my rent, but I lost my job, or my mum was sick, or whatever, more than just the dog being sick, which is the usual reason for not paying rent.
Yeah, but as I said before, if you get the council involved on them being made homeless, there are options they have. They can come to an agreement to pay off arrears. They can come up with ways of paying.
Yeah.
There's lots of ways to it. Going back to your comment about other things, I think if it's arrears, that's quite clear cut. I think if it got to antisocial behaviour or bad habits, then they've got to be a lot more careful about how they deal with it, because they've got to think about mental health issues.
Exactly, yeah.
And make sure that there isn't a mental health issue that they haven't dealt with. Or judging by how swamped they are, I think Birmingham gets 400 inquiries a week, and that was before COVID.
Yeah.
Totally agree.
Totally agree.
But the thing is as well, they've got to do a whole case history on it, because they've got to properly document it, which I know is a bugbear to them, because they bring it up at the meetings I go to. But that's why I suggest going to the homeless department, because that might give you the leverage you need. All right, it might not be an ideal condition, but if you can get your rent and you're only missing 2 months, and they can even jig it so that they can pay some of that and distribute it off their benefits over the year.
Do you know what's tricky about this, Carol? And I just say it for completeness. It kind of, every landlord, every situation you have to look at differently. But one of the things that's genuinely a bit difficult about this is that actually the arrears can be very useful in assisting in evicting. And I just say that transparently. In other words, I think it's important that any landlord weighs up what's more important. Is this about money? And you might be back against the wall with your mortgage or whatever it is, and not have a choice. It's kind of, we need to try and pitch for the local authority to pay something to offset the problem. Or can we effectively use those arrears to assist in the repossession claim? And right now, that may not be such a big deal because of, say, Section 21s. But in the future, where they're gone, this is going to become much more of a live issue. And I would say to most landlords, would I be actively pursuing the local authority to encourage payments whilst I'm actually really trying to evict? I don't know. I probably wouldn't. I'd probably say you need to weigh up that decision. What's more important, the money or repossession? And I would say repossession, but that's me.
What a good point you make there. What a good point.
But then again, I think making it clear to them that they are intentionally making themselves homeless, because a lot of them think that there's plenty of council housing. Quite how, I don't know.
I know.
Because there isn't.
I know.
And I know that
Carol,
the social housing, the social providers, they're experiencing real bad arrears.
Yeah, and they will, because they only have access to Section 8s now. Again, it is very difficult, because what I'm not trying to do is make it really hard for the tenant to live somewhere else. And so the easier it is for them to have alternative accommodation, the better for me, for my clients, for the landlords, because they'll then leave and they'll have somewhere else to go. We're not trying to increase homelessness, God forbid, or anything like that. It's simply, we own a property, we need to regain possession of it. And so I'm not trying to kind of force that issue against the tenant, because it's just not in the landlord's interests personally. But it is, again, different landlords, different circumstances, different kind of views on all of this. And you have to weigh it up. And hopefully you never have to weigh it up, because you're never getting this problem. But you're in the game long enough, there's going to be something, isn't there? But look, I hope that all helps. And look, there we go. If I can help, come back to me. But I hope that's useful. Good seeing everybody, and I'll try and sort of keep in touch via the Slack groups and Facebook and things. But yeah, all good.
Any
As
more?
ever, a learning experience.
Okay, thank you very much, Alex, and thank you for coming, everyone.
Yeah, Alex, that was fantastic. Thank you very much indeed. Riveting.
No
It will
problem.
be on the YouTube channel.
Great.
Yeah.
Good stuff, everybody.
Okay.
Thanks very much, all.
Good weekend to everyone. See you Monday. Thank you. Bye-bye.